Here we go, folks. November 17th, 2023 is a huge day for the Second Amendment because that is the day that the U.S. Supreme Court justices are going to be taking up and considering whether or not to grant cert to Brian Range versus the United States. And Merrick Garland is running like a little school child trying to say, don't take the case. Don't take the case. You're not going to believe the crazy arguments as to why he says the Supreme Court should not take this case, which we will review in 1 minute. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans, and Israelis for that matter, about the right to bear arms. All right, folks, so big news today. The U.S. Supreme Court issued an order saying that they are distributing for conference. The November 17, 2023 conference, the case of Merrick Garland versus Brian Range. As you recall, this involves a federal gun control statute, 18 U.S.C. 922 G1, which deals with felons in possession, specifically those who have been convicted of a crime deemed a felony under federal law. They are not allowed to possess firearms for the rest of their lives once they are convicted of that. And if they do so, they go to prison or 18 U.S.C. 922 G1. Brian Range was convicted about 20 some odd years ago of a misdemeanor under Pennsylvania state law of apparently omitting a few $100s in lawn mowing or landscaping income from his application for food stamps or welfare or something along those lines. And he pled guilty to a misdemeanor. He never served a day in prison or jail or anything like that. He was never viewed or deemed to be dangerous. He's never committed any violent crime or done anything violent in his life whatsoever. And he sued to challenge the federal law 18 U.S.C. 922 G1, again, which says that if you're a federal felon, you cannot possess firearms for the rest of your life. He challenged that on what's known as an as-applied basis, as applied to him, and said that simply because he's not dangerous, it is unconstitutional under the Second Amendment and, of course, subsequently under NYSERPA versus Bruin, which is the Supreme Court case of 2022. I'm happy to report that Brian Range did indeed ultimately win his case before the United States Court of Appeals for the Third Circuit, which is the court that covers Delaware, Pennsylvania, and New Jersey. Specifically, the en banc court, which is the entire Third Circuit Court of Appeals, concluded that as applied to Brian Range, he could not be disarmed for the rest of his life based upon pleading guilty to a non-violent misdemeanor in Pennsylvania that required him not to serve a single day in prison, notwithstanding the fact that the crime he pled guilty for, conceptually, I believe, had a potential more than 2 years in prison penalty. The Third Circuit says no can do. This violates the Second Amendment and violates NYSERPA versus Bruin, and therefore it doesn't apply, and he gets his gun rights back, and period, full stop. Basically, you remember the story that Merrick Garland decided to rush out and push the Rahimi case because Mr. Rahimi, unlike Mr. Range, has a record that looks much more odious. So Merrick Garland really had a choice here. Despite running the Department of Justice, in my view, Merrick Garland has no interest in justice whatsoever. He is a party hack. He is a partisan attorney who represents the agenda of the hard left in America and the President of the United States and his hard left advisors. That is the harsh reality, including the anti-gun supporters of the president. So therefore, Merrick Garland, rather than doing the just thing, which is to take a legitimate case of Range, he decided he wanted to push the Rahimi case, even though the relevant provision of Rahimi deals with 18 U.S.C. 922 G8, which is literally gives rise to about 20 convictions per year, and in contrast to 922 G8 G1, which has thousands upon thousands of convictions. But Merrick Garland, rather than running the Department of Justice, rushed off and shoved a case involving a statute that is literally never enforced in American life except for a handful of times a year, and decided that was the proper precedent-setting case that he wanted the Supreme Court to take up. So Merrick Garland sought certiorari ori in Rahimi months before he went out and did it for Range. So while he rushed the Rahimi case, he slow-walked the Range case to the last possible date and then sought cert. So now the question is, what will the Supreme Court do? I'm happy to report that, again, the Supreme Court is now looking at this case seriously. On November 17th, they referred the range case for a conference, which means the 9 justices will sit down in a room together and they will discuss and decide whether or not to hear this case. It requires 4, I repeat, it requires 4 justices to vote in favor of taking the range case. We will know more on November 17th, specifically the days thereafter. I should warn you that if they're going to grant cert, what will happen is the following, almost certainly. On November 17th, they will meet. There will be 4 justices or more that indicate they are interested in taking the case. Let's assume that's the case, of range. If they show an interest in taking the case, then under the modern rules of Chief Justice John Roberts, he wants to make sure there's no jurisdictional defects. If there's 4 or more justices that indicate an interest in granting cert, he will then hold the case over, which is often referred to as relisting. Relisting that case. That relisting indicates that the Supreme Court is then investigating whether or not there's any jurisdictional defects involving things like standing or anything else along those lines, and a case could be relisted a couple times and pushed over to the next conference or the next conference thereafter as the court makes sure, because the last thing the Supreme Court wants to do, because they take so few cases, is to grant cert in a case and have it turn out that it becomes moot. They do not like to do that. They consider that a waste of their time, and they hate doing that. And that's why, if there's interest in taking this case on November 17th, the first indication that will be true is the following week, the case of range will be what's known as relisted, meaning it will be relisted to be reconsidered at the next conference, which I think takes place in early December. That's what we should all be cheering for. Now, it turns out that Merrick Garland and his Solicitor General's office filed a reply brief today arguing that indeed the Supreme Court should not take this case. Let me remind you why the case, of course, should be taken and why range should be taken. Because simply put, the first thing is you want to stop Merrick Garland. If I were on the Supreme Court, stop Merrick Garland from playing games. He obviously played games by picking Rahimi over range, but don't allow him to do it. Number 2, of course, is the reason why the government did this is they desperately want to keep Mr. Range's case away from the Supreme Court, especially this term, because they know just how weak their arguments are against Brian Range. While the government has strong arguments, arguably, against the allegedly dangerous Mr. Rahimi, they don't have those same arguments against Mr. Range, which is why the Merrick Garland says, please don't take the case now. Take the case down the road, but not right now, because they don't want to muddy the waters. They want a clear shot to win the Rahimi case because the guy is such apparently a bad dude on this record and violent. The other thing, of course, is the government outrageously is making the case that it's up to Congress. Hear me carefully here on this point. It's up to Congress to determine who they get to disarm. Congress gets to determine if they get to disarm you. Congress gets to determine whether or not you're a danger. Well, specifically, they say that they don't have to show dangers. What Merrick Garland's Department of Justice is saying is that the Congress gets to determine whether or not you are a law-abiding and or a responsible person. If you're not law-abiding or you're not responsible as defined by Congress or by state legislatures, then they get to disarm you. That is obviously insane. The notion that I could irresponsibly spit on the ground or drive 5 miles over the speed limit or, put trash in a recycling bin or a whole host of silly administrative quote-unquote crimes, and thus I lose my gun rights for life is simply absurd. And don't forget, we've talked about these two Latin notions before. I've driven it home to you who've been following the channel from day one, the difference between a crime that's known as malum in se, which means evil in and of itself. This is a notion of murder, rape, robbery, battery, assault. These are things that are inherently wrong, and you would know they're to be inherently wrong even in a state of nature with no laws whatsoever. That is in contrast to what Merrick Garland wants to be used to disarm Americans, which are what are known as malum prohibitum crimes. Malum prohibitum crimes, which means simply they are wrong or illegal by virtue of simply being defined as wrong and illegal by our congressional or legislative betters. There's no inherent moral authority or anything immoral about your action other than they simply have drawn the line in a different direction. That's why if you have a barrel on a rifle that's under 14 inches or something like that, that is an arbitrary line. There's nothing malum in se or evil about having a short barrel rifle, let's say, or short barrel shotgun. But of course, the legislature has said that's a problem, and that's an example of a malum prohibitum crime. Likewise, a magazine that holds more than 10 rounds, there's nothing inherently evil about that one way or the other, but that is the sort of of thing that's a malum prohibitum crime. And I want to let you know that St. Benitez, Judge Roger Benitez in California, has specifically talked about this distinction between malum prohibitum and malum in se crimes. And I'm happy to report that when he did so in the first decision involving Miller versus Bonta, he did indeed quote scholarship of an extremely handsome YouTuber who has wonderful real hair. And I think you all know who Judge Benitez was talking about when he quoted that handsome YouTuber. I'll let you guys take it from there. Now, just to give you a couple specific arguments that Merrick Garland is making as to why he doesn't want the range case taken or why he thinks the range arguments are wrong. The first thing, believe it or not, and let me be clear about this. This is my opinion. I really think what's going on here across the country with these blue state judges, a lot of these anti-gun judges, is they're trying to game the system. And I think Merrick Garland and the Department of Justice are doing the same. And the real reason, if you really put them to the test, and you really ask them under oath why they're doing this, I think the reality is that the anti-gun movement in America does not like the current composition of this Supreme Court. They simply find it to be too pro-Second Amendment, too willing to protect individual rights over government overreach, and I think they don't like that. So I really think there is a delay until someone dies strategy. Sounds harsh, I know, but I really do think that the Department of Justice, and I think a lot of these blue state judges around the country in certain anti-gun jurisdictions are trying to delay getting any kind of gun-related case to the U.S. Supreme Court because they really don't want this court to decide it. They really want to replace, if they can, to replace Justice Alito or Justice Thomas with a Joe Biden selection to the Supreme Court. They think that would be much more favorable to them. So that's why the real reason why I think the anti-gunners in America, including the Department of Justice under Joe Biden, are trying to drag their feet in every single way to prevent more favorable pro-Second Amendment precedents from getting on the books by the Supreme Court. So I really do think that is a big part of it, which is why in their brief, Merrick Garland's Solicitor General's office writes, in sum, the range case provides no sound reason to depart from this court's usual practice by granting certiorari now rather than holding this case for Rahimi. Remember, it is Mr. Range who said that this case should be heard because remember, both Range and Merrick Garland both have agreed that this case should eventually be heard by the U.S. Supreme Court. The only question is, should it be heard this term or in a subsequent term? Mr. Range thinks that this case should be heard immediately alongside with Rahimi, and Merrick Garland thinks that it should be delayed until long down the road after the Supreme Court decides Rahimi. We'll see what the court does. We'll know more about this in the next several weeks. The other thing that Merrick Garland argues is that he goes on to say that, it's interesting that the court sometimes hears multiple cases involving a single constitutional right, but that is different than the Rahimi situation because he says Rahimi and Range oppose different questions. But that's exactly right. Even though there's a lot of similarity in that they're both dealing with the same overall statute, 922G. One deals with 922G1, which deals with individuals who've been convicted in a criminal court. And now the question is, what is the consequence of being convicted after all those due process protections in a criminal court with a criminal conviction where you could have served prisons for more than 2 years? What's the consequences under the Second Amendment to that scenario? That is much different than that's different than the Rahimi case, which is when can the government engage in what's known as preventative justice, i.e., disarm someone or take someone's gun away from him or herself before there is any kind of a criminal case or even outside of the context of a criminal case, because 922G8 has nothing to do with crimes. 922G8 says that if you're subject to a domestic violence restraining order, which indeed is a civil process, when can we take away your guns? So Rahimi deals with civil cases, and Range deals with the consequence of being convicted under the criminal law. So they're dramatically different, although they are related. And ultimately, the answer we want in the Second Amendment community, as I see it, is that indeed, if someone has actually been found to be a violent physical danger to themselves or to others, they can be disarmed during a period of time while they are indeed violently dangerous to themselves or to others, but that can only occur after a robust process where ample due process protections are provided, something that absolutely, I think, was not available and was not given to Mr. Rahimi, and that's what I think we ultimately are going to want. But let me carry on and talk about the other argument Merrick Garland makes. He goes on to say that he really wants to be able to use, and the Supreme Court should use, these proposals by states during the state ratification conventions But again, these were proposals to the Bill of Rights or to the Constitution during the state ratification conventions in the 18th century, where the various states were considering whether or not to vote for and adopt the United States Constitution in the first instance, because one of the issues there was A, should we adopt the U.S. Constitution? B, if we adopt the U.S. Constitution, should we also adopt a Bill of Rights? And C, if we adopt a Bill of Rights, what are the sorts of rights we'd like to be found in that Bill of Rights? And it was during this back and forth and debate and discussion, you had certain proposals in some of the states that Merrick Garland, the Department of Justice, thinks would be favorable to the anti-gunners, but the Supreme Court has already said these kinds of proposals are dubious laws because they were never adopted. So why on earth would the Second Amendment meaning be affected by laws that were proposed and rejected and never adopted? What does that have to do with the price of tea in China? Which is why the U.S. Supreme Court has referred to these proposals at these ratification conventions in the 18th century as dubious in terms of helping to understand the meaning of the Second Amendment. But then Department of Justice Garland, and this is an example of Mark Smith is always ahead of the game, okay? Do not kid yourself. Here's an example. Remember I told you that the anti-gun movement is all about hiring historians to tell airy-fairy stories about history, the story arc of history. You know, Abraham Lincoln is gay. All this kind of stuff you'll see out there in various contexts around the country in various places, and how you want to see, in my view, the anti-gun movement wants to embrace historians that can tell stories as opposed to what the Supreme Court said in Bruin they have to do, which is to find very specific historical analog laws to show a long-standing tradition of actual regulation of firearms rights in America. And here's an example on page 5 of the reply brief where Merrick Garland specifically says how he's trying to get out from what Mark Smith said he has to do. This is what he writes, quote, like Rahimi, Range seeks to reduce the interpretation of the Second Amendment to a rote archival search for founding era laws that match the challenge statute. Yes, exactly. That's what the Supreme Court says. Because what they really want, think about what Merrick Garland and the Department of Justice want. They want to identify non-existent laws that never existed, laws that were not adopted by the founding father in the 18th century. Then they want to say, look at those laws that were never adopted. We want to prove that today's modern day 21st century gun control law is justified by virtue of a bunch of laws that were never actually adopted or never even conceived of at the time of our founding, because it makes a whole lot of sense and helps us win the case. That is simply absurd. And it goes back to exactly what I said, that at the end of the day, the only thing going for the anti-gunners, and in my view, the only thing that's ever gone in favor of the anti-gunners when it comes to restricting our right to keep and bear arms is airy-fairy history, and I would often call it airy-fairy non-history, and the Supreme Court is nipping that in the bud, which is why they're saying, no, you got to show actual gun control laws that were on the books. Now, they could be case law, could be common law, could be statutory law, could be constitutional law at the federal level, could be constitutional law at the state level. There has to be something to talk about. But you can't, if you don't like guns in America, come forth and say that we can pass a modern gun control law that has simply no analog law at the time of the founding. That is simply not how the Supreme Court interprets the Second Amendment, under the text first and then history second. That's not how the government can meet its burden. The government has to do a lot more by showing either a relevantly similar or a distinctly similar analog law at the time of the founding, depending on whether or not that social problem that the modern gun control law is trying to resolve, whether or not the problem is the same problem that persisted since the 18th century. And virtually every single issue that the modern gun control laws, but the modern day gun control laws are trying to address now, are dealing with issues such as crime, street crime, domestic violence, and so on. These are problems that have existed since the time of our founding. That's right. When in doubt, the Supreme Court has said in Bruin, you err in favor of freedom. All right, folks, hope you learned a little bit something here today at the Four Boxes Diner. If you haven't subscribed, please do so. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.